Please.
Good morning, Your Honors. May it please the Court. My name is Donna Aldea, and I represent Appellant Simon Watts.
Something interesting about the trade-off on that ruling. If you open this door, something may come through later on, right?
Absolutely.
You want to lead with that?
Sure. That was actually my plan. So with respect to
I
that...
do not read minds, counsel. I just do my homework.
So with respect to that, the problem with that trade-off is that it was, as the defense attorney accurately stated at trial, apples and oranges. The reason that it's well settled that the pecuniary interest of a witness at trial is relevant to their credibility, so in other words, a witness who has a pending civil suit is interested in the outcome of the criminal trial because a conviction at the criminal trial can help them obtain millions of dollars in the subsequent civil suit. The problem here is that while that is a standard and well-recognized ground of cross-examination, the court created a Hobson's choice for counsel. It said, if you exercise your right, your constitutional right, to cross-examine the witnesses on this motivation, which is well settled in law, then I will allow the people to elicit uncharged crimes evidence showing that the defendant, in this case alleging sexual abuse of his students, actually had engaged in 12 prior instances of sexual abuse against other uncharged students. So 12 instances of uncharged crimes. And the reason this was apples and oranges can actually be seen for three independent reasons. The first one is that when you look at the test, or the basis for opening the door evidence, which is really what's at issue here, in People v. Macy, the Court of Appeals said, in deciding whether the defendant has opened the door to otherwise inadmissible evidence, the court should consider, quote, whether and to what extent defendant's evidence or argument is incomplete and misleading, and what, if any otherwise inadmissible evidence, is reasonably necessary to correct the misleading impression. Well, here, the defense's argument was very clear. By having a pending civil suit, by merely the existence of that suit, that imbues the witnesses with a pecuniary interest in the outcome of the trial. The question of what their motivation was for bringing that civil suit, in other words, whether they were seeking to vindicate their children's rights or to alert the school board to the fact that they can't allow this to happen to other children, has no bearing on that question. There was nothing misleading about defense counsel saying the pecuniary interest in the outcome of this trial is a basis for credibility. So there was nothing to correct under the standard articulation of the test.
And not only that, but, and this is not necessarily, at least I haven't seen it in the law books, there's a very human and practical component to it. The defense counsel, by making the proffer and advising the court, giving the heads up that the court, that counsel wishes to explore this, is making, hopefully, a strategic choice, because if the court had granted the application without the opening of the door specter, counsel is taking a chance in coming across as demonizing parents who are standing by their children, especially with the gravity of the charges against the defendant. Be that as it may. Interesting. So anything else on this point? Because to me it's rather clear.
Yeah, there's actually just a couple of things that
it's called living on the edge.
I can't address in rebuttal, so I just want to address it now. There are two specific points. The first one is preservation. So the prosecution is going to argue, they argued in their brief, that part of this claim is unpreserved. Specifically, they argue that while the defense attorney preserved her objection to the elicitation of evidence of a newspaper article alleging that in 2005 there were two prior allegations, she then claims that the subsequent elicitation on the defense case by the prosecutor on cross-examination from the principal, that after this 10 other students came forward with their own allegations, she claims that that is unpreserved because the defense attorney did not specifically object. So I just want to note that with respect to preservation, the prosecution likes to talk about the statutory requirement in 470.05 of timeliness and specificity. What they don't tend to highlight is the other component of 470.05, which says that a claim is sufficiently preserved if the party, quote, makes his position with respect to the ruling known to the court, and it also states that a party who without success has expressly or impliedly sought or requested a particular ruling is deemed to have thereby protested the ultimate disposition.
I'm certain there was an oversight on the part of learned counsel, not an intentional omission.
Well, so the point is that this is preserved. There were over 50 pages where this defense attorney vehemently objected to the admission of this incredibly prejudicial evidence.
Let me see if I can be helpful, because you have a lot to tell us. I'm certain. Record speaks for itself. Your next point?
The next point has to do, the next point that I actually want to address, there is a cumulative error point that contains probably about, 10 or so subsidiary points, and I know that the court has read those. I'm not going to go into all of them. The only one that I'd like to highlight is the prosecutorial misconduct point. And the reason that I'd like to highlight that is because the prosecutorial misconduct point actually really sums up the problem with the cumulative error in this prosecution, in this particular trial. And in this case, while it's clear that summations are rarely, if ever, perfect, mistakes are made, things are always said that maybe should have been better left unsaid. But when the errors are so pervasive that they become a theme, then it becomes a problem that warrants this court's invocation of its interest of justice jurisdiction, as it should in this case, and that can be deemed to rise to the level of depriving the defendant of a fair trial. In this case, the three themes, the three pervasive themes in the prosecutor's misconduct were these. First, that counsel's style or demeanor in speaking to the jury should justify discrediting her defense. Second, that the defense theory was, quote, ridiculous and merely, quote, a distraction. And third, that the defense, not the prosecution, but the defense, needed to prove certain facts to permit the jury to find the defendant not guilty. These pervasive themes are illustrated throughout the brief, and I'll just briefly address them, but they clearly show that in this case, combined with the other error, with the elicitation of uncharged crime evidence of 12 other incidents of abuse that were not before this jury, this rose to the level of depriving the defendant of a fair trial.
Counsel, did we have overwhelming evidence here? We have 5 different children, I believe, that were, your client was charged in abusing 5 different children. So the cumulative errors you're referencing, do they move into a harmless fear if you really look at them, each one distinctively, and look at the 5 testimonies of the children?
So the answer is, in this case, the error was not harmless, is the simple answer. And the reasons for that are actually twofold. But I think that, so I'll start from an evidentiary standpoint and then move to a legal standpoint. From an evidentiary standpoint, the errors here were not harmless because in the end, this was nothing more than a credibility contest between the defendant, who took the stand and testified and said, I didn't do this, and these 5 children who testified that he did. The children's accounts obviously had problems. There were discrepancies between statements they had initially made and statements they made later. Some of the cumulative error points actually deal with the fact that the court's rulings did not allow counsel to elicit some of those crucial discrepancies, particularly with the first student who reported. And then additionally, there was an absence of evidence that is deemed to be corroborative or probative or overwhelming in other types of cases. Like, for example, there was no confession by the defendant in this case, like there is in other cases, that would tend to overwhelmingly support guilt. There was no physical evidence in this case showing that the defendant had actually abused any one of these children. There was no corroborative evidence in the form of a witness who had witnessed the abuse aside from the children who were testifying.
Although there was no issue as to access and no issue as to identity.
Well,
we're talking about classroom settings for lower school children.
There was no issue about identity. About access, I would actually defer with that conclusion because in this case, the allegations were that the defendant was abusing these children by and large, with one exception, was abusing them by and large in the middle of the class while there were 30 other students seated in the classroom, at his desk when there was an aide that was sitting on the other side of the room, another one that was walking around, and when the principal was coming in and out of the room. Some of these allegations that actually grew as the case went on, that started out with nothing more than a touching and eventually became allegations that every day he would call a student up to his desk. This one particular student testified, every day he would call her to his desk, and in the crowded classroom, he would ejaculate on the floor and actually clean that up, an allegation that was never made at any point in this litigation, in the grand jury, in the discovery, until trial. So there were actually a lot of problems with access in the sense that it really didn't make a tremendous amount of sense.
But counsel, there was also testimony from perhaps the paraprofessional or other aide in the classroom that did not support your client's testimony. The positioning of the desk, there was some testimony that another adult in the classroom was not able to say that she could see your client's desk or see his body from below his shoulders.
Well, that didn't contradict anything. It is true that the other witnesses, all the other witnesses were very clear. They said, we never saw any inappropriate touching, we never saw any abuse, and some of them said they were in the room. The principal said that he would come in the room unannounced, sometimes unannounced. There was a window in the door which was next to or adjacent to the defendant's desk that would be seen. So none of it was inconsistent. It is true, Your Honor, you're correct in stating that the other teacher in the classroom stated that from where she was seated at the other side of the room, she wasn't able to see the lower part of defendant's body. So that's absolutely correct. But that doesn't support guilt. It doesn't show that he was guilty. It doesn't help the people. It just shows the absence of that evidence. But now let me address it more directly, probably more probatively, and as Justice Rivera would say, I should have started with that strongest point first maybe. But from a legal standpoint, I'd like to address why this is clearly not harmless. The answer to that is 3 words: People versus Huddy. People versus Huddy is a Court of Appeals case where a teacher was charged with abusing not 5, but 8 students. 8 students came forward and testified against him, and there was also corroboration by another person who did not make the allegations that they witnessed one of the incidents of abuse. At that trial, where 8 students testified, the prosecution improperly, just like in this case, was permitted to bring in one student who was not present when all of these allegations were being made at the school, who testified to a prior uncharged crime. In other words, this one student, who was not the subject of the criminal charges, was brought in to testify that he too had been previously abused by this defendant. The Court of Appeals found, as this court should find on point 1, that that was error. It found that the error was prejudicial. It found that there was no basis for that, and that, as in this case, the probative value of that testimony was far, far outweighed by the prejudicial impact. But here's the best part of Huddy, and the part that the people do not distinguish in their brief, even though it's the critical reason that we cited the case. The court found that that error, the one uncharged crime, was not harmless. Now, compare the facts. In Huddy, you have 8 students testifying the defendant did it, corroborated by an eyewitness who also saw it. In this case, you've got 5 students, no eyewitnesses. In Huddy, the prejudicial error was that one prior uncharged crime was brought out. In this case, the primary prejudicial error, not even getting into all of the other cumulative stuff, was that the prosecution elicited evidence of 12 other uncharged crimes. 2 instances in 2005, which actually were deemed unfounded, although the jury never would have known it. 2 prior incidents in 2005 from a newspaper article that defendant had abused students in a prior school, and 10 other allegations that the prosecution, the Queens DA's office, decided not to charge these people. But 10 other allegations that students came forward after the fact, which I would note the prosecutor named those students by name at trial, even though there was no evidence as to those charges, came out. So if the error was not harmless in Huddy, Your Honor, clearly 10-fold over, maybe 12-fold over, the error was not harmless here. And here, as we discussed, the error does not stand alone.
Counsel, is Huddy distinguishable because in Huddy the witness actually testified rather than the names being revealed? Is that a way to say that we're not bound by Huddy?
No, Your Honor. And the reason for that is if you look at the court's reasoning in Huddy, the reasoning was not that there was witness testimony. Actually, arguably, it's less prejudicial when you have a witness testify. If you have a witness testify, then the defense attorney
Because of cross.
can challenge the witness's credibility. In this case, being deprived of that, all the jury was told is there were 2 other allegations of abuse in 2005, and 10 other students came forward making complaints after this. So we have 12 uncharged crimes with no ability for cross-examination, and with the jury never learning that those incidents actually didn't have tremendously high probative value, as they were unfounded or weren't sufficiently egregious or criminal to form the basis for criminal charges. So it's far worse. My final point, Your Honor, is actually just deals with the sentencing. And the sentencing is, it's true, kind of an alternative point in the sense that what we're asking, of course, is for a reversal of the conviction. But on the sentencing, I just want to note that the court actually at sentencing was told that the people's plea offer in this case prior to trial was a sentence of probation. Now, there's no question that there can be a sentencing disparity between what a defendant is offered prior to trial and the sentence he gets. But I have never seen a sentencing disparity going from probation to a top count plea to 35 years incarceration, which is what this defendant got here. I would also note that—
What did the people ask for at sentencing?
Excuse me, Your Honor?
What did the people ask for at sentencing?
They did ask for the maximum sentence concurrent,
Went
which is
from probation to the max.
I'm sorry, consecutive, which is in fact what this was.
Right, which is what the judge gave them.
Which is what the judge gave him. Now,
So what you have never seen, I think we had just my last sit with that same kind of plea offer and sentence. So I think you need to speak to some other issues as to sentence.
I will absolutely do that. And if the court has seen it, I'm hoping that the court reversed or at least reduced the sentence, because in other cases, that's what this court has done on facts that are similar to this. Now, every case, of course, has to be evaluated on its own facts. In this case, what is significant is nothing else came out at trial that the people were not aware of before. In other words, they knew before that there were these 10 prior uncharged crimes. They knew before what the allegations were going to be.
In a case involving sexual conduct against children, isn't one of the overriding considerations for a plea preventing the children from having to testify? So just that factor alone, does that not normally cause an abyss between what might be offered prior to their testimony and when in fact the child does testify?
That certainly is a consideration. However, that consideration cannot then be used punitively, as the court did here, to penalize the defendant for exercising his constitutional rights.
Well, it's not. It's the child actually testifying, the specifics as to the child, the impact on the child, which is then before the court. So it doesn't just so it doesn't have to relate whatsoever to penalizing.
Well, so here's another problem with the court's sentence in this case. One of the things that a court has to do is a court, in order for the sentence to not be an abuse of discretion, has to necessarily exercise discretion. So in this case, we know for a number of reasons that this judge did not exercise any discretion. The first way we know this is that the judge essentially made clear through his sentence that he appreciated no distinction between the charges that were made by one student who claimed that on a single occasion, defendant with his hand brushed his penis over his clothing before giving him candy, and the allegations of another student who claimed that every day over the school year she was forced to touch the defendant's penis and ejaculate on the floor. To say that each one of those offenses is both worthy of the same 7 years makes no sense. And it reveals that the judge absolutely did not weigh the proportionality or the effect or the consequences or the gravity or the quantity or the quality of the different offenses. And that means that that sentence is not entitled to any deference by this court because it was not based on any discretion whatsoever. The second thing, Your Honors, is that we know in this case that the sentence was not based on what the judge actually, on a weighing of the applicable factors, because the other thing that the judge did not consider is the defendant's criminal history in this case. The judge did not consider that this defendant had zero criminal record prior to this incident, that there were over 17 letters of support from various members of the community that detailed the fact that this defendant was raised in an abusive household, that he pulled himself out of poverty and abuse, he educated himself, he got involved with the church, he became what every person at this trial, including the child witnesses, I think with the exception but one, claimed was an excellent teacher who cared for the children and who helped them and who taught them well. All of those factors, his history, his lack of criminal history, his background, the fact that he was lovingly married, the fact that he had 2 children, the fact that he was involved with his church and there had never been another instance like this in his past, were not given any weight whatsoever. So for those reasons, Your Honors, I would submit that the sentence was disproportionate and the sentence was an abuse of discretion. But I would urge this Court.
What sentence would you seek under these circumstances?
Your Honor, I think that
You can punt on that one if you choose.
I think that what would be fair in these circumstances is certainly a concurrent sentence as opposed to a consecutive sentence, and I really do think that it should be the minimum permissible jail sentence on these offenses. And so that would amount, at this point, the defendant has more than served that sentence already. But I would urge this Court, the sentencing, as I said, is an alternative position, and as Justice Rivera said, for that reason, I may want to punt on it, but my real argument to this Court is, no matter how heinous the allegations are against an individual defendant, and in fact, particularly when those allegations are most heinous, that's when it's most important for a court, the trial court and this Court, to most jealously guard the defendant's constitutional rights and due process right to a fair trial. This defendant was never given a fair trial in court. He did not have a fair trial because of the cumulative error, because of 12 prior uncharged crimes to which the door was never conceivably opened, and because ultimately of a summation that was littered with a prosecutor disparaging the defense attorney, calling her arguments ridiculous, inviting the jury to ignore the evidence in the case, and ultimately asking the jury at the very conclusion to say, quote, "You can't find somebody not guilty based on a maybe," which is exactly contrary to what this justice system is all about. If the answer to the prosecution's case was a maybe, which is what it should have been, they were mandated to find the defendant not guilty. So this Court should now afford the defendant a new trial.
You know, it's interesting because I can't help but try to connect things that have nothing to do with cases with my life experience. There's a wonderful line by a wonderful actor in a certain movie. It's a good thing that I was about to tell you we have your argument and you went beyond, not quite the requested time, but the allotted time, because I'm afraid, or if I had not, you were just getting warmed up.
Thank you, Your Honor.
Al Pacino. It's a wonderful line. You were just getting warmed up, and I'm certain you are already warmed up and ready to go, so we can't wait. Thank you, counsel. People, you're up.
Good morning. May it please the Court. Nancy Fitzpatrick Talcott for the respondent.
Would you be kind enough to either choose to go from the first issue in sequence, or if you want to reverse the sequence, or anything else that you care to do? I think the battle lines, and I mean that clinically, have been eminently well laid out by the justices and by your learned colleague on the appellant side, so we're looking forward to what you have to say. Please.
I'll start with the first point. First of all, there are 2 separate issues regarding the prior uncharged crimes. The first dealt with the civil suit that came out through one of the parents. There was no distinction between the two. The 2 reasons for bringing the civil suit were not independent of each other. The Court, therefore, properly determined that in raising the one, it opened the door to the other. Defendant asked about the civil suit to posit that the money was the motivation behind everything. Not just in bringing the suit, the allegations were made out of whole cloth. Someone said something untoward, and others went wild. The parents pushed and manipulated the kids. If you're motivated by a desire to ensure that this doesn't happen again and punish the city or the Department of Education, then the monetary or pecuniary interest that the defendant posited is diluted. So that's crucial in this case.
Has there been a settlement in the city case?
I actually think it was just recently, if I'm not mistaken.
And do you know what the amount of monies were?
My opponent thinks one was 5.
Excuse me?
She thought one was 5. Is that HB?
I apologize, I'm not hearing you.
5 million?
So to say that there's a pecuniary interest, counsel,
Yeah.
to say that there's a pecuniary interest is to put it mildly.
Absolutely, and the court was correct in recognizing that and said, this is absolutely ripe for cross-examination, but then the question is, there were also other motives behind bringing the suit, and they're connected. And that's why questioning with regard to one opened the door to the other, because it diluted the strictly monetary thing. And you're also claiming under the defendant's ascribed purpose for the civil suits, they're making up everything. You're not going to make up something to punish. You're much less inclined to make up something to punish somebody. For example, the DOE, the principal of the school, for prior knowledge, as opposed to just making up something for pecuniary gain, which are the allegations. And that was really the underpinnings of the defense, that the whole reasoning behind the criminal case, the allegations were for pecuniary gain. The snowballing effect was all for pecuniary gain, everybody hopping on this. Now, separate and apart from that, on direct is when the principal testified as to uncharged allegations. We would stand by our position that it is unpreserved. The colloquy defendant cites in their reply brief on page 1059 and 1060, it's clear what the defense attorney took issue with was with the court's restriction of her questions of the principal on direct. She references the people's questions, and then she says, I believe there was nothing improper about me asking whether or not the principal of the school was made aware of whether or not any of these complainants had made allegations. Shortly after that, she says, I don't understand what was not proper about me asking the principal of this school, who actually said these kids came in. So we would argue that any claim regarding the prosecutor's specific questions is, in fact, unpreserved. And in any event, again, for a separate...
How do you get the uncharged in? What was the... I mean, it's so prejudicial in a case like this. And how do you get around the Court of Appeals case that seems to be staring us in the face?
Well, I do think Huddy is distinguishable, because in here the principal testified that from 2007 to 2010, he got no complaints. So what he's really putting out there is that during this time, there was no misconduct, there were no real-time complaints. And because there were no real-time complaints, he's positing that they were manufactured after. So that, therefore, opens the door. I would liken it to a character witness. So he says, well, I didn't know of anything happening during this period. Well, were you aware that these 5 children are now claiming this? Yes. Are you aware that there were other allegations? Yes. And that's all it was. Unlike in Huddy, the Court of Appeals case, which I do think is distinguishable, that witness was called to buttress the specific claims of the victims who testified in that case. Not only that, the grandmother, to whom he had outcried immediately, testified to what he said as well. These weren't admitted to buttress the claims of the victims who testified. The first was admitted to set forth an alternative grounds for the civil suit, which, like I said, diluted the purely pecuniary motive.
Again,
and here...
Counsel, can you focus on the prejudice? It just seems so... The court's supposed to engage in a balance. It seems so highly prejudicial to allow alleged fact that he allegedly abused 12 other students, and I guess I'm missing the context. Like, and that prejudice is weighed against what? Weighed against a misimpression.
The misimpression that his conduct was beyond reproach during this 3-year period because there were no real-time complaints.
But in the end, so the claims that came out after trial or after he was charged affect this 3-year period. That's your position, and therefore...
Yes, because therefore
the jury had a right to know it.
Because the conduct took place during the period, they were kind of suggesting his conduct was beyond reproach, that he was this stellar teacher because they didn't get real-time complaints.
All right.
In any event, we would argue that it was harmless because the 5 gave detailed testimony, the jurors saw the witnesses.
Do you think that... Again, respectfully, so a statement that he abused 12 other kids is harmless because 5 kids testified that he abused them, that's essentially your argument?
Well, I think they gave powerful and detailed testimony regarding the abuse.
That is your argument?
Well, yeah, because that was the evidence. And regarding the summation, this claim is completely unpreserved for the court's review. Defendant objected to only one of the comment, didn't do so on the grounds raised on appeal,
seems
and
as
didn't
if-
object to any of the other comments.
Counsel, it seems as if in the summation they were, which I'm just trying to figure out the reason, that they're almost denigrating the individual defense attorney and her whole, I mean, it sounded almost like sexist. Am I misreading it? I mean, it's just almost scornful that this is a female defending this guy. It came to me, and maybe I'm missing the point.
I didn't personally understand the point of it. I do.
You don't see the point of the way she...
Of just commenting that she screamed and yelled. I mean, the jury saw it. I don't think it denied the defendant a fair trial. I don't understand why she pointed out it was her demeanor. But I would like to note defense counsel herself recognized it. At the end of her summation, she apologized for yelling and screaming. She said, look, remember, I didn't have to do anything. I didn't have to say anything. A lot of you are probably saying to yourself, God, I wish she didn't. My ears would hurt less. So I think then that ended her summation. The prosecutor began with a comment on it. I don't know if she picked up on that. That tracked that. I don't think it denied him a fair trial.
What about the maybe comment?
The maybe comment,
You concede that was a mistake?
yes. Yes.
it goes to-
I
it
think
goes
it's
to the
just
very hardest of
inarticulate.
what-
I'm not even sure what she was going to, or unless,
But it doesn't it imply that the standard of beyond a reasonable doubt?
No,
If you think it's a maybe, he's guilty? mean,
I just think it was a very inarticulate statement. I think it was responding to defense suggestions that they speculated. It was an inarticulate argument to make. I would not say it was correct, but there was some call for speculation in their argument. I think a better word would, remember, don't speculate. Not, you can't do it on a maybe. I don't think that single comment or any others denied him a fair trial. You know, they asked, during the defense summation, he said, they don't feel comfortable coming forward with themselves. Why didn't they feel comfortable coming forward that the teacher was touching the other teacher? Look at the arrest report. Now, the court sustained an objection as to there was some time disparity between HB's allegation and the defendant's arrest. And he said, look at the police report. Look at the arrest date. Arguably inviting them to speculate. All right, maybe they didn't believe HB. So I do think it was just a very inarticulate and not great way to just say, look, you can't base it on speculation, base it on the evidence.
What about the sentence then?
The claim really is that it was punitive, and I think the court made clear that, a lot goes into it, and I think Justice Roman was touching on this, especially in a sex abuse case, not having the victims
what
testify.
troubles me, though, is that the state considered this gentleman so little danger to the public that they were willing to let him off without any prison time. And I understand the need not to have young children testify, but they were so not worried about him that he was going to get a free ride other than lose his job and take a guilty plea, and the state said he was going to pay millions of dollars. So how do you go out there and have fun, you pedophile, whatever the hell you want to call him, to 35 years? How do you go? That's what I was, as I read it, I kept trying to say, did he really give him 35 years? And the state really asked for it after basically saying, you're out of here. It just makes no sense.
The state actually didn't set forth a number after some discussion. I think she said they would ask for close to the maximum. They didn't actually ask for a specific amount, but I think as close to the maximum as.
What about counsel's argument that the singular touch outside the pants to daily disgusting comment each warrant 7 years? How does that show any discretion by this judge that it's a he, right? That he actually
Yes.
considered the facts in this case?
Well, the facts were clearly before him, and I think.
But how do you justify? Counsel, just
I-
focus on that.
Right.
How do you justify 7 years, one touch outside the pants to daily ejaculation? How do you justify 7 years for both? Make the argument to justify it.
Because I don't think you should be rewarded for sexually abusing one child less than another. And I think
You
they're
think-
both so egregious that it's
You think giving
within
him...
his discretion
Okay.
that both warranted. Just because you abuse someone a little bit less
This
than
sentence
another.
This sentence is more than a violent rape sentence that your office regularly gets. Much more. Right? Is this comparable?
I wouldn't know what we regularly get, but yeah, it would be comparable.
Okay.
But, you know, the claim was that it was used punitively, and I think the court made clear that it didn't. It didn't consider the plea bargaining process. It wasn't involved in the plea bargaining process. 5 children did have to come in and testify to this. Parents had to come in. So, you know, there are factors that would justify or explain a disparity between the trial offer. And he wasn't getting off scot-free. In addition to losing his job, he would have had to register as a sex offender, and there are other consequences to
understand
pleading guilty. If the court has no questions?
Thank you both.